And we are joined now by one of the signers of that statement, Gene Rossi. He's a former assistant U.S. attorney for the Eastern District of Virginia. Also joining us, Democratic Congressman Hank Johnson of Georgia. He's a member of the House Judiciary Committee. He will have to decide whether to vote to hold the Attorney General in contempt of Congress. And Dahlia Lithwick is with us. She's a senior editor and legal correspondent for Slate.com. She is the host of the podcast Amicus and one of the great legal authorities we have on this program. Gene Rossi, let me start with you on this document, which is unlike anything I've ever held in my hands.
I agree.
With all of these federal prosecutors. What brought you to sign this document?
I have a moral compass, and I am embarrassed by the antics of the people who are running the Department of Justice. Lawrence, what's important about this document, this letter, is it's Republicans and Democrats, but there's one signatory that people have sort of ignored. Don Ayer was Deputy Attorney General of the United States Department of Justice under George H.W. Bush, 89 and 91, or 90. The same time that Bill Barr was head of the Office of Legal Counsel, and Bill Barr replaced Mr. Ayer. So for Mr. Ayer to sign this document is not only a courageous act, he is saying that Bill Barr's analysis of obstruction of justice is insane.
And Congressman Johnson, let me go to you on this. I want to get your reaction to the prosecutor's letter, and then also where it stands tonight, as far as you know, between Chairman Nadler and the Attorney General.
Well, it's actually an extraordinary letter. It's a development that gives me confidence about the fact that we'll be able to protect our republic, preserve the rule of law, and ensure that we get down to the bottom of any attempts by the Trump administration to obstruct the Mueller investigation.
And what do you know about Chairman Nadler's negotiations at this stage with the Attorney General or the Attorney General's staff? Do you think there's any chance of coming to what the chairman calls an accommodation before that 10 a.m. vote that is scheduled for Wednesday morning?
Yeah, the chairman and staff of the Judiciary Committee have been almost daily in talks, oral communications with the Department of Justice staff about reaching a reasonable accommodation. We realize that the Department of Justice has certain interest in protecting information that they have, but we also insist upon being able to carry out our prerogatives as the first co-equal branch of government, the legislative branch. We've got oversight, we've got legislative, and we've got constitutional prerogatives that ensue as a result of this investigation, and we are hell-bent on making sure that we carry it out and get to everything that happened and air it out to the American people so that we can take appropriate action from this point.
Dahlia, this is one of those big days for historians. There will be that document, that first document that the House Judiciary Committee has generated with the words articles of impeachment regarding President Trump. But I want to go to you first about this letter that Gene Rossi and so many of these other prosecutors, many of whom you know and have covered, whose work you've covered over the years, who have signed on to this letter. What do you make of the legal presentation, the legal scholarship presented in the letter?
All I can say is the same thing I said a week ago about the note that Bob Mueller sent to William Barr that shocked all of us because it looks as though it's lawyerly and careful. But if you read what lawyers write, that was explosive. That was almost excoriating Barr for his conclusions. This is the same thing. This is talking about multiple felony charges of obstruction that are for which he's eligible. This is not mincing words. And so I think one thing is that they're not in any way being cagey in the letter about their conclusions of law. And they're not being cagey about, I think, as you pointed out, saying that Barr's findings, his legal analysis, just doctrinally is straight up wrong. To me, I see this as a way of saying, look, Congress has an independent constitutional obligation to look at these obstruction claims because Barr punted it. In fact, he did more than punt it. He papered over it. And obstruction is an impeachable offense. I see this as saying, Congress, it's your turn.
And Gene, let me go back to you on this.
Yes.
What do you see as the most important element of obstruction of justice that you see in this case, President?
It's the corrupt motive. And to me, the corrupt motive is entirely obvious. He is asking the White House counsel to not only lie to other people and to get the White House counsel to make representations to the Attorney General, but he's asking the White House counsel to create a false document that history will look at. That is incredibly disgraceful, and that satisfies corrupt motive. The president obviously knows there's an ongoing investigation, and it did attempt to impede. And that's the key, Lawrence. You don't have to succeed with obstruction. You have to attempt. When you swing at a fastball and you miss, the swing is the crime, even though you missed the fastball.
And Congressman, what do you think a letter like this would mean to your colleagues on the Judiciary Committee with its specificity about what and these are experienced prosecutors, and we keep hearing Chairman Nadler and others saying we need to see the full unredacted Mueller report. These experienced prosecutors, without seeing the full unredacted Mueller report, have seen enough to, in effect, bring their own, in effect, public indictment against the president.
Well, I think sensible Americans can see the redacted report, see the broad outlines and the conclusions that are made by the Mueller investigators, and they can see that although Mueller did not accuse the president himself of obstruction, he did leave it up to Congress. And he left it up to the American people to make a judgment about the evidence that he laid out. He laid out a roadmap towards constitutional action against the president in light of the Department of Justice opinion that a sitting president cannot be indicted. So what Mueller did was laid it out without commentary to the American people. I think most people can see that, yes, there certainly is probable cause to believe that the president obstructed justice, not once, not twice, not 3 times, but over 2 handfuls of times. And it's pretty clear.
Congressman, what can you tell us about the possible date for Robert Mueller's testimony to your committee?
Well, that is still under investigation, still under negotiation. May 15th is a target date, but if that date is not the actual date that is arrived at, I think it should be at some point very soon thereafter. So I'm optimistic that the committee will be able to reach an agreement with Mueller's representatives, and Mueller will testify. And if the president tries to keep him from testifying, then we'll go back through this process of subpoenaing Mueller, and I don't think he will take the same attitude as Barr has taken, which has been to just be flippant in their response to legislative oversight. I believe that Mueller will respond, and it should be pretty easy to get him into the witness chair, and I'm looking forward to it.